So you got served with a restraining order or a protection order or even a no contact order in Washington State or Seattle. What should you do now? Well, I can tell you what you should do. My name is Fryrear. I'm a defense attorney in Lynnwood, Washington. Our firm has been handling restraining orders in Seattle and all throughout Washington State for over 20 years. In this video, I'm going to cover 3 things. What is a restraining order? What to expect in the court process? And how to best prepare for the restraining order hearing that you're going to have to face, usually about 2 weeks after being served with a restraining order. If you stay to the end of this video, you can also download our guide about tips about fighting a restraining order. That's available. Just stay to the end and we'll give you the link to do that. So what is a restraining order? Restraining order usually means someone has went to court without you there, ex parte, that means one-sided, and told the court, hey, I have a problem with the respondent. The respondent being, if you're watching this video, you. The types of restraining orders typically are anti-harassment, stalking, or domestic violence. And in any case, the petitioner, the person complaining about you, has went to court and had an ex parte hearing, a one-sided hearing, where they said, well, these are the reasons why I'm being disturbed by the respondent. They're calling me all the time, they're threatening me, maybe they beat me up, those type of things. And judge, I don't feel safe. Issue an order that will stop the respondent from contacting me or coming near me. And the judge usually rubber stamps that. They just sign it, and then all of a sudden you get a knock on the door, and the police give you this restraining order, and you don't know what to do. So if you violate the terms of a restraining order once you've been served with it, you'll go to jail. Most violations are a gross misdemeanor, 1 year in jail max, $5,000 fine max, and some violations can be a felony. So it's super serious. So you get served with this order and you don't know what to do. So what's the court process? Again, the second thing I want to talk about is the court process for fighting a restraining order. Well, it wasn't very fair to start out with. You didn't even have a chance to go to court. But now you've been served with this paperwork. And you look at the paperwork, and there's a petition in there. And the petition is what the petitioner wrote for the judge to review. And that's what you need to answer for the court hearing. So you're going to have on the top of the order will be what we call a return date, a date you need to go to court, usually 2 weeks later. And if you fail to go to that return date, a default order will usually be issued against you, which means there's going to be a permanent order against you. A permanent order means a year or more. So you need to do something, and most people make a mistake. They just show up at the permanent hearing, and they figure the judge is just going to listen to their side of the story, and they're usually very sadly surprised that the judge only gives them a few minutes to talk, doesn't really listen, and seems like they might have their mind made up already. And that makes sense. The court process, if you do it that way, works like this. Just before the permanent order hearing where you're showing up, the court reviews the file, and they see all this bad stuff in writing about you, the respondent. And if you haven't filed a response, they come out and they've seen all this bad stuff and they haven't seen anything good or anything to deny what happened. And while it would be nice to think that the court can spend half an hour or an hour on your hearing, usually the court only has a short period of time to hear these hearings. And so you need to file a response prior to the hearing so you have a fair shake. But again, how does the court hearing work? There's no jury. Basically, the petitioner shows up in the court. You are allowed to show up in the court, just don't talk to the petitioner or sit near the petitioner. Eventually, the court will call your case. They'll usually have the petitioner speak first. Just, do you have anything to add, Mr. or Miss Petitioner, about in addition to what you wrote? And then they'll add some stuff or not, and then they'll say, okay, respondent, I'm going to swear you in. What do you want to tell me about what the petitioner said? The judge can ask you questions if they want, and then the judge makes a ruling. If the judge finds that the petitioner has met his or her burden, an order is granted. The burden is a preponderance of the evidence. Is it more likely than not that the petitioner suffered harassment or domestic violence or stalking? And those are all legal terms, so you should contact an attorney or do some research online to find out what it is that the petitioner has to prove to get his or her order. If they haven't met their burden, the judge rules in your favor, then the judge just cancels the order. You don't get paid anything, you don't get any costs, you just get to walk out without having an order against you. So the third thing I was going to tell you about, and again, stay tuned to the end if you want the link to our guide about tips about fighting restraining orders. The third thing is how to best prepare for a restraining order hearing. The best thing you can do is contact an attorney, because an attorney will have experience and know what to write and what not to write. But if you are just going to do it yourself, you need to write out a response and file it with the court and try to have it served on the other party legally, usually by somebody else, because you don't want to violate the order. You need to do that before the hearing. It's pretty complicated. That's why you probably need to talk to an attorney. But if you are going to try to do it yourself, beware a couple pitfalls. If what you're accused of could be a crime, you may not want to talk a whole lot about it, especially if you don't know how to say it in a way that doesn't implicate yourself. Well, the petitioner's accusing me of keying their car. Well, I didn't key their car, I only kicked the side of the car. Well, that probably wouldn't be good to put that in your response. Additionally, we tend to think that people decide on facts, F-A-C-T-S, facts, but really people decide on emotion. So when writing a response, we have to sort of tell the whole story. We have to be able to make an emotionally true rendition of what happened, so you have the best chance for the judge to rule how you want. And that's difficult. Again, you're better off talking to an attorney, but if you're going to do it on your own, you have to follow the court procedure. You have to be careful to not admit to any wrongdoing, and you have to put some background in so we can hit some emotional points the court will care about. All right? So those are the 3 tips that I wanted to go over about how to defend yourself against a restraining order or a protection order. Again, my name's Lance Fryrear. I'm the owner of the law offices of Lance Fryrear. If you want some good help or good advice, you can give us a call. We've been defending these type of matters for over 20 years in Seattle, Lynnwood, all throughout Washington State. And click on the link right here next to me on this screen, or you can type it in, and you'll be able to download our free guide about tips for defending a restraining order in Washington State. If you need anything, just give us a call. We'll be there for you.